It's a great pleasure to introduce our keynote speaker today, Professor Josepch Carens, who is Professor of Political Science at the University of Toronto. Although now a resident of our northern neighbor, Professor Carens was American by birth and a graduate of the College of the Holy Cross and Yale University. He has held positions at the Institute for Advanced Study at Princeton, at the Université Catholique de Louvain in Belgium, at the Institute for Advanced Study in Vienna, and the European University Institute of Florence. Joe taught for a number of years at Princeton University before being lured away to Toronto, where he and his wife, distinguished theorist Jenny Nadelsky, are members of what Joe told me yesterday are a complement of no less than 10 political theorists in the political science department at Toronto, and I'm sure my non-theory colleagues here today are all thinking, and heaven help them. In any event, Joe is the author of numerous works of the earlier Equality, Moral Incentives and the Market, and an editor of a collection, Democracy and Possessive Individualism, The Intellectual Legacy of C.B. Macpherson. But his most central and recent concerns over the past few years has been directed toward the ethics and politics related to the problem of immigration. Migration, membership, political community, which happens to be the tentative title for a forthcoming book that he is writing on the ethics of immigration, is one principal contribution. And in this area, he's also generated a large complement of rich work, including numerous articles and books. The book is Quebec Nationalism Just? Perspectives of Anglophone Canada, he is the editor of, and more recently, Culture, Citizenship, and Community, the Contextual Exploration of Justice as Even-Handedness. He'll be speaking to us today on the topic of who belongs, the ethics of integrating immigrants, and so without further ado, Joseph, I turn things over to you.
Thanks a lot, Shannon. It's a great pleasure to be back here at Berkeley, where I spent a very enjoyable summer about 23 years ago. So my talk today is part of a larger project. As Shannon said, I'm writing a book on the ethics of immigration, and I'm just going to give you a little piece of that at the beginning. The main question I want to address today is how the legal rights of immigrants should resemble or differ from the legal rights of citizens. And if there's time, I'll try to say a few things also about access to citizenship for immigrants and for their children. Throughout the talk, I'm going to adopt the most conservative background presupposition about admissions, namely that states have a right to admit or exclude non-citizens for whatever reasons they choose. Now, elsewhere, in the book and some other writings, I criticize this view of a state's right to regulate admissions. I think there are questions one can raise about that, but none of the arguments I make today depend on those criticisms. So even if you take the most conservative view, I think the arguments I'm making today will apply. So the central theme of my talk is that living in a society makes one a member of society. Immigrants who become long-term residents have to be regarded as full members of society. And their status as full members has implications for the bundle of legal rights they should have as residents, for the terms under which they and their children have access to citizenship, and for the modes by which they are integrated into the receiving society. As I said, I'll focus primarily on the question of legal rights. And the talk is structured by looking first at the legal rights of immigrants with the strongest claims, long-term legal residents, people who have been here for a long time. Then I turn to three other groups with progressively weaker claims: people who have just recently arrived as permanent residents, temporary workers, and then unauthorized residents, asking in each case how the entitlements of these groups might differ from those of the previous one. As a final introductory comment, let me make a few points about the overall framework of the analysis. First, I've been struck over the past few months whenever I talk with anybody about immigration, they say, oh, you hot topic and so on, and so often people frame it in terms of September 11th. And that's understandable, as it's given the traumatic nature of the assault, and it undoubtedly also reflects an important political reality. If one discusses some issue around immigration today, it will be framed that way politically. But intellectually, I think it's misguided, especially with regard to the ethics of immigration policy, and even more so with regard to questions about the integration of immigrants. To put it very starkly, I don't think that September 11th, the events of that and its implications, are highly relevant to any of the issues that I discussed today. So that'll be one controversial thing I'll toss out at the beginning. I have to do something to provoke discussion here. Well, second, my analysis is normative rather than empirical, but that doesn't mean it's detached from practice. In fact, I pay attention not just to the practice of the United States. I think people in the United States often take too parochial view of this. You should look more comparatively in thinking about immigration issues. People in Europe often are similarly parochial in the sense they say, oh, well, North America doesn't apply, their countries of immigration, we're not, it's a very different circumstance. Now, all of the, you know, there are distinctive things about each society, each political culture that matter, but also there are deep commonalities among liberal democratic states, and that's what I'm going to draw attention to today. So I'm trying to make claims that I think apply broadly across the liberal democratic states of Europe and North America. Another kind of controversial claim. People want to emphasize difference. Here I want to emphasize similarities. I think there are widely shared understandings of what justice requires with regard to immigrants, despite the differences in history and circumstance. I'll just add here my own personal perspective on these issues has been shaped by my experience of being, on the one hand, a third and fourth generation descendant of Irish immigrants to the United States, and then being myself an immigrant to Canada. In fact, as Shannon suggested, see, I'm one of those dual citizens that some people are always warning you about. And maybe already you can see why, or will so by the end of the talk. Finally, I'm focusing on formal legal rights. As we all know, administrative interpretations and practices can render formal rights ineffective, or more rarely provide greater protection than people are technically entitled to receive. Also, social and economic arrangements may be far more central to immigrants' lives than legal rules of any sort. But nevertheless, I do try to talk about those things more fully in the book that I'm writing, but the main presupposition here is that legal rights do matter to the integration of immigrants, even if they're not the only thing that matters, or even if they're not the most important thing. Okay, so I want to start with the question, is citizenship special? Equal citizenship in modern liberal democratic states begins with the commitment to equal legal rights for citizens. But what about non-citizens? How should the legal rights of immigrants resemble or differ from the rights of citizens in a liberal democratic state? People tend to think of citizenship as special. Indeed, the idea that citizenship is the special status that distinguishes insiders from outsiders is so deeply rooted in our traditions of thought and expression that it's sometimes hard to recognize how poorly this fits with our actual practices, how rare it actually is to reserve rights exclusively for citizens, and how difficult it would be to justify doing so. If there were actually the sharpest divide is probably between residents on the one hand and non-residents on the other, not between citizens and non-citizens. So let's consider how liberal democratic states actually allocate legal rights and whether these allocations are justifiable, beginning with the extremes. On the one hand, rights granted to everybody, and on the other, rights granted only to citizens. So in many cases, liberal democratic states provide legal rights to everyone within their jurisdiction, even if they're there only on a temporary basis, like tourists. Think of such things as the right to protection of your person and property by state authorities, the right to the police, if you're robbed, they don't ask, where are you from, if you're from France, we're not going to protect you. You're supposed to be protected against assaults and so on. If you're accused of a crime, the right to a fair trial. If you're accused of a crime, the right to emergency medical care. In principle, citizenship status is supposed to be irrelevant to the enjoyment of these rights. In fact, in principle, these rights are clearly possessed even by those who enter or stay without formal authorization. In practice, of course, such people are often reluctant to bring themselves to the attention of the authorities, but in principle, just because you came in without permission doesn't mean that you can be assaulted in the street or robbed and so on. So they're rights of persons, not citizens. Here's an example. There's no plausible moral justification for distinguishing between citizens and non-citizens in legal procedures designed to determine the guilt or innocence of an accused person. Different countries have different legal traditions. Some, have prohibitions against self-incrimination, some don't, and so on. They have different rules of evidence. But however those requirements are defined, they apply to all defendants within a given jurisdiction. It's not about citizenship. You can't adopt different rules of evidence or different rules regarding the burden of proof for citizens and non-citizens. Citizens, it's proof beyond reasonable doubt. Non-citizens, it's the balance of it. That would be absurd, right? You have whatever your rules are, this is how we're going to determine guilt and innocence. They have to be the same for everybody. It's a context in which citizenship is not supposed to matter. Now, there are some areas where citizenship, but just a few really, is clearly supposed to matter and generally does. The right to vote in national elections, the right to hold high public office. Those are usually limited to citizens in all the countries of Europe and North America, all countries really. And if one thinks of legal citizenship as the status possessed by full members of the political community, it makes sense to limit these key political activities to citizens. restriction of legal rights to citizens is both empirically common and normatively defensible in these cases. And really the question there is, well, who gets to be a citizen? And do we have everybody in that category that ought to be? Which I hope I'll get to at the end. Well, many legal rights fall between these two extremes. They're not possessed only by citizens, but they're not possessed by everyone either, and that's what I want to look at today. So consider first the legal rights of long-settled immigrants, people who are here, they're settled, they have a right to be here, they have a right of ongoing residence, long-term legal residence. Let's start with them. Well, a number of scholars have drawn attention to the extensive erosion of the legal distinctions between citizens and resident non-citizens throughout Europe and North America during the late 20th century. So, at the beginning of the 20th century and throughout the early part of it, there were very significant distinctions, and non-citizens were often very subordinated and very limited rights. But that's been changed, partly through political means, partly through court rulings, and so on. Some legal distinctions persist, especially in the area of political rights, access to public sector employment, and under certain limited circumstances, protection against deportation. And there have been some reversals of this trend. The U.S. legislation of 1996 restricting the access of legal residents to means-tested redistributive social programs, and the growth of rights for EU citizens that have not been extended to third country nationals. Still, I want to claim these are relatively minor reversals in the broad scheme of things, taking a broader perspective. And the basic pattern remains clear: convergence between the rights of citizens and the rights of established residents. So that's the basic pattern. You start at the beginning of the century, tremendous differences. By the end of the century, relatively few. Should we applaud that development or criticize it? Well, in my view, the answer is clear. The reduction of legal distinctions between citizens and residents is a move in the direction of justice, and one that should be extended still further. Once people have been granted the right to enter and remain in a state, their position is completely different from that of outsiders trying to get in. Living in a place makes you a member of civil society. People develop interests and attachments that the state is morally obliged to respect. And the longer they stay, the deeper the interests and attachments become. At some point, they reach a threshold when they should just be treated as full members of civil society, with virtually the same legal rights that citizens enjoy. And that's, I think, what has been gradually recognized in almost all the countries of Europe and North America, frequently as a result of courts finding that restrictions on non-citizens are incompatible with some basic legal commitment in a constitution to fairness or equality. And I would argue that apart from the political rights, the remaining distinctions should be abolished. Three major areas stand out. First, all these states have exclusion of permanent residents from much of the public sector. And it's just a blatant form of discrimination that has no plausible justification beyond the discrimination itself, that is to say, it's an attempt to give an economic advantage to citizens over residents. A class of economic opportunities. There's no justification about it. We're not talking about high public policy positions or national security positions. We're talking here about, just ordinary bureaucratic jobs in the post office, and, or in any kind of public service job, where there's no special policy-making responsibility, no special security issues. They're just jobs. And that's been recognized in the European Union, for example, by the fact that now in the European Union, these sorts of jobs have to be open to other European Union members. They're citizens of other countries, but they have to be open to other European Union members. But they're not open to the residents. You can be, so you can be a resident in Germany and not have access to these jobs that somebody from France does, even though you've lived there all your life. And it's just, it's just a straightforward form of discrimination, in my view. Same thing in the United States, same thing in Canada, and it's just something that ought to be changed. It's an unreflective vestige of past patterns of discrimination and serves it's out of step with what we've come to see about that norm. Second, once people have lived in society for a number of years, this will be more controversial, I think, there's no justification for deporting them if they commit crimes. This, of course, goes against the trend. People are keen to let's get rid of the criminals. And that's true in Canada as well as the United States. It's commonplace to deport people who are convicted of crimes, even if they've lived in the receiving society since childhood. I was just reading a few days ago, you probably read about this case in Wisconsin. Some poor guy, he's lived in Wisconsin since he was 3, So then he's, smoking dope and get convicted for marijuana, trafficking, whatever. He's had various convictions. And now he's being shipped back to Afghanistan. I mean, he's never been to Afghanistan. He knows nothing about Afghanistan. He doesn't speak Afghan. Now, I mean, this guy doesn't seem to be so bad, but let's say he was a terrible. Sometimes these people are terrible. They do terrible things. They're, killers. They're horrible. But whose problem are they, after all? If they've been living in our society since they're 3, there are problems. You know, we're the ones who are, not the Afghanis or, you know, wherever it is. They're not responsible for the social formation of these kids. We are. So why are we going to dump these people on somewhere else? You know, just take responsibility for our own social problems and deal with them. It's just not fair. It's blatantly unfair. In fact, quite a serious problem in many cases when you send the worst people. If you send them to these countries, they don't have the resources to deal with them. You introduce it. It's really a scandal. So, you know, and it's one of these things that I don't have a lot of optimism about this changing because it's terribly politically popular. You know, shall we keep the criminal or get rid of him? You know, how'd you like to vote? It's very simple. You know, everybody's clear how we're going to vote on that, but it's just outrageous, you know. So that's the basic. And of course, it's not fair to the individual. Criminal rights aren't so popular, but really, put them in jail. They committed a crime. Put them in jail. That's fine. But then deportation on top of that is just severe. We don't allow it. You know, you don't get to send people to Devil's Island anymore. You know, they're horrible. You're citizens. They're horrible. But you don't get to export them. You know, even if you could get someplace to agree to take them, we could probably work that out, right? You can get a country, buy an island. But we don't get to do that. It's a violation of human rights. And so why do we think we can do it to these non-citizens? Finally, there's no justification for excluding long-settled immigrants from redistributive social programs, as recent American legislation has done. Like other people, immigrants are vulnerable to illness and other unforeseen circumstances that can render them in need of assistance. As established residents, I'm talking about people who've been here a long time now, 5 years, say, maybe 10 years, whatever. They've contributed to the taxes that pay for these programs. So they're entitled to receive whatever protection society provides its members against such misfortunes, great or small, but they're entitled to receive it. So while these distinctions between citizens and long-settled residents deserve criticism, we shouldn't lose sight of the fact that the distinctions actually affect only a small minority of resident non-citizens. And they pale in comparison to the systematic and widespread differentiation between citizens and residents that was common a few decades ago in both Europe and North America. So to restate the main point, on the one hand I want to criticize these things, but really current practices in liberal democratic states draw very few distinctions between citizens and permanent residents, apart from the right to vote and the right to hold public office. And that's, in fact, the way it should be. Very few distinctions. Okay, so far I've considered people who've been settled for a long time. I didn't specify what a long time meant. I said 5 years at least, you know, maybe it'd be longer. Now, given my general argument that the moral claims of immigrants to full membership grow stronger over time, it's natural to ask, all right, so what do they have when they first arrive? Before they have this claim of having been there for a long time. How does that affect the kinds of legal rights they should possess? So let's look first at people who are admitted without restrictions on their activities. Maybe as in the United States and Canada, they're admitted as permanent residents from the outset, or as is more common in Europe, they're admitted on some more temporary basis, but with a right to continued renewal of these residents and eventually gain permanent residence. Doesn't matter. They've just arrived. There are two areas, I think, where sharper distinctions between citizens and such immigrants are defensible. Not always advisable, but defensible, during the period immediately after arrival. And that has to do with security of residence and access to redistributive social programs. Well, first, both the interest that people have in staying in a society and their moral entitlement to stay increases as they sink roots and form attachments, establish connections in the receiving society. And that's normally related, closely related to the amount of time people spend in a society. So take the idea of security against deportation. If somebody arrives as an immigrant and commits a serious crime shortly after arriving, in the first 12 months, 2 years, whatever, it's reasonable to deport him after he finishes his sentence. So in contrast to what I was just saying, this is something different. Then you're not responsible for who this person is. They arrived, they commit a crime, so you made a mistake. You admitted somebody, you thought they're a criminal, so you can deport them back to the original country. The immigrant won't have had much time to establish the connections that bind one to the new country. The country isn't responsible for his social formation. So that's legitimate. But the longer a person stays before committing a crime, the less appropriate it is to add deportation to the penalty for the crime itself. At some point, well, I'd say 5 years. Maybe somebody else wants to argue it should be 10. I don't know. It's the details of the numbers. But at some point, it's clearly no longer appropriate. Deportation should no longer be an option. And so that clearly applies to anybody who's spent much time as a child here. And then you can argue about how long it should be for somebody who comes as an adult. Okay, means-tested social programs provide another area where one can argue that time matters normatively to the rights that immigrants can claim. These programs are not directly contributory. They're funded by the better-off members of society to assist the least well-off members. So there is an argument to be made that people who have recently arrived are not morally entitled to immediate access to such programs. especially if their admission was explicitly tied to their not needing such programs. This is true in Canada, the United States, and elsewhere. They say, well, we'll let you in so long as you have a sponsor or something. You're not going to need access to the programs. So I'd say it's probably not unjust, though in my own view, I wouldn't be in favor of this. I think it's ungenerous. I think it's unwise. But I don't think it's unjust to deny rights to redistributive benefits to relatively recent arrivals. But again, that justification erodes with time. So, as I argued above, that laws like the one in the United States that permanently exclude resident non-citizens from income support programs are unjust. And in practice, few other states in Europe and North America impose even temporary limits on access to such social programs. But apart from these two areas, it's hard to think of any legal rights that are allocated to long-term residents that should not be available to immigrants from the outset. Well, for example, say there are contributory programs or insurance schemes, so unemployment insurance, workers' comp, compulsory health insurance. Well, it's blatantly unfair to require people to contribute to such programs and then deny them the benefits, right? That violates the norm of reciprocity. These programs are built on the idea you share the risk, you share the benefits. Well, share the risk, we would never mind about the benefits. It's hardly fair, right? That's the normative foundation for these things. And most liberal democratic states recognize this in their practices. Occasionally you see one of the areas, when immigrants are admitted on a temporary basis, they're required to contribute to pension funds like Social Security, but they're not going to be allowed to stay long enough to get access to there's something objectionable about that. You have to pay in, it's a compulsory tax, it's designated for these programs, but you're not going to get access to them. Well, why is that fair? But that's the exception. For the most part, people do get access to them. And of course, some of these have waiting limits, which apply to everybody, and the waiting limits would apply to the immigrants too, but no longer. So there should be the same rules for all. So you have to be working for a certain amount of time before you're eligible for unemployment. That's fine, but it should be the same for all. It shouldn't depend on citizenship status. States used to limit the civil rights of non-citizen residents, like the right to join unions or express political views. Sometimes they did so directly. They said you can't do it if you're a non-citizen. Sometimes indirectly. Oh, yeah, you can do it, but if you do it, we'll deport you. It's not a crime. You got a right to do it. And so clearly that's as bad or worse in terms of preventing them from exercising their rights. For the most part, not entirely, those practices have ended, and rightly so. These are the sorts of rights that enable people to live full human lives, to participate actively in civil society. It might or might not be possible to justify limiting some of these rights for people who are admitted only as tourists or short-term visitors. I don't try to address that, should they have the right to, participate in politics and so on. But once people have been permitted to live in the society, then no such justification is plausible. Well, what about people, now temporary workers? So that was people who are admitted on an ongoing basis. Well, what now about people who are admitted not, with the idea they're not going to be there permanently, temporary workers? And temporary workers is the subclass of this group. If you think about this class of people who are admitted subject to limited time and limited conditions, it includes things like people like tourists or students or various sorts of workers, seasonal workers, border commuters, guest workers, visiting professionals, so on. Well, I want to focus on temporary workers just because they're the ones who most resemble immigrants and most likely to seek to become immigrants. So how do and how may the rights of temporary workers differ from those of citizens and permanent residents? Well, the first, most important difference, of course, is the restricted duration of the right to remain. Temporary workers are entitled only to stay for a limited period. Citizens, permanent residents are able to stay indefinitely. And I would say that restriction is permissible, provided that the workers are actually present only for a short time. What's not acceptable, so you can say you can have a program, people can come in for a year or two, that's okay. But what's not acceptable is to keep people in a temporary status which is constantly renewed. So they actually stay for a long time, but remain in a vulnerable and restricted situation. The general principle enunciated above still applies. The longer you stay, the stronger your claim to be regarded as a member of society, and so entitled to the rights of membership. So, if someone comes to work in a place for a year or two, she doesn't have particularly strong claims to remain. But after 5 or 6 years, the case is very different from a moral perspective. And that's so even if people are admitted with explicit limitations on their rights to stay. This is surely the lesson to be drawn from the European experience with guest workers in the 1960s and 1970s. The guest workers had been told from the outset that they could not stay permanently. They'd agreed to come under those terms. No one made them come. No one forced them. They consented to these restrictions. So you might think, well, then everyone should have agreed it was legitimate to send them back when the economic conditions change. We don't need you anymore. Or at least the ones who had lost their jobs and so on, let's send them back. But that's not how the guest workers themselves saw it. It's not how many European citizens saw it. It's not how the courts saw it. In the end, the European states found themselves unable to send most of the guest workers back. which stands in sharp contrast to the mass deportations that took place in the early part of the 20th century. There's been a shift in our understanding of what is reasonable for states to do. In the face of the obvious deep connections of the guest workers to the places where they had moved, the original terms of admission had become irrelevant. As time passes, temporary workers are entitled to become permanent ones. And with the right to stay come the right to be treated as a full member. Well, in a similar vein, this hasn't been developed as much in practice, seasonal workers who come back year after year, in my view, have stronger claims than ones who come for only a year or two. And the longer the season, the stronger the claim. The Swiss used to have a policy. They had this faux saisonniers. They'd bring people over. They'd be there for 11 months. They'd go home for a month's holiday, and they were called seasonal workers. Then they'd be back the next year. They were permanent residents, but they were called because they were seasonal workers. Then they could be treated with all these, not have all these rights. Well, you can't get away. I don't mean to say you can't do it empirically. States can do all kinds of things. We're here talking normatively. You can't have a plausible justification for that kind of policy. The second important way in which the rights of temporary workers differ from those of citizens and residents is that temporary workers are usually much more restricted in the kinds of work they're permitted to do. They might be limited to a particular kind of work, sometimes limited to a particular geographic area within the country, sometimes even restricted to a single employer. Well, in some cases, this is a transitional status, which leads to permanent resident status and the fuller sets of rights that go with that. Canada has a program like this it used to be called the nanny program. Basically, the idea was you couldn't get Canadians to work as live-in nannies. So they'd say, all right, here's the deal. You come for 2 years, or 3, it started out 3 years, and you work as a live-in nanny with this, somebody makes a contract to you from abroad, and you come and you get to stay 3, and after that you become a permanent resident. In addition, they had to go to school, they had to do all these, had to prove yourself a model citizen, learn English, go to school, and work all these. So that was the basic idea behind that program. And you can see the dilemma. So people are very critical of that program. It's been reformed in various ways. They've reduced the restrictions. They've made it 2 years instead of 3. They've permitted people to switch employers. At first they were tied to one employer. But the basic dilemma you face at the end of the day is this. The people who get in under this program will not get in unless there's this specialized program. They don't meet the Canadian criteria for admission otherwise. There are a lot of women from the Philippines. There are too many people applying from the Philippines. They're not going to be at the top of the queue. So they can only get in if they have this program. So you have the choice. Do you say, let's continue with the program, which has its problems, everyone knows, or not? Now, if you just admitted them straight, of course, they wouldn't become nannies. Why? As soon as the 2 years are up, most of these people, because it's a lousy job, most people don't want to do it. If you're willing to pay enough, of course, you can get people to do it, but under what people are willing to pay for it. So, there's a way in which the exploitation is built into that kind of system, You say, well, why not let the market take place? If you raise the prices of wages of live-in nannies high enough, you will find people who will be willing to do it. But it's not, by the time you raise them that high, there are very few people who can afford it. So clearly there's something problematic about any of these kinds of programs that depend on the kind of restriction. Yes, there are people out there who are willing to do it, but gee, there'd be people willing to sell their organs and willing to do lots of things, So the question is whether this is an acceptable way to exploit people, if you will. So some people just say, no, let's not have any of it, and I can understand the appeal of that approach. I think, I'm ambivalent, is really the truth. As are the people who actually represent these, for example, these nannies in Canada, there are 2 groups who represent them. They're completely divided on this. One group wants to abolish the program altogether. The other wants to, kind of reform it, but as long as there's a program, it's going to have this built-in feature. So I think it might be possible in any event, if you're going to have such arrangements, it's clear that you can't have any other restrictions other than the ones that are tied to the need for this kind of labor, right? So you can't add on restrictions of, and you have to make those restrictions minimal. So you can't tie people to a single employer. You have to be paying attention to the way in which these programs inevitably generate a vulnerability. And so you have to take special precautions if you're going to have any such programs at all. I'll leave open the question whether you should have any of those kinds of programs. Finally, let me turn to yet a more controversial topic, that of unauthorized residence. What legal rights should be possessed by those who reside and work without official authorization? Sometimes these are people who enter legally, so they don't enter illegally. They overstay a visa. They came illegally. Sometimes they come as refugee claimants, and if that doesn't work, they go underground. Sometimes they evade immigration controls from the very beginning when they cross the border. And these differences don't matter for my purposes here. The point is they're not staying with authorization. Now, those who are opposed to such people call them illegal aliens, to draw attention to the fact their activities are incompatible with the immigration laws. Those who are in favor of such people call them undocumented or undocumented workers, to suggest it's just a paper problem here, if only they had picked up the right paper, you know, and to emphasize that they're workers. They're workers. Well, I try to use the term unauthorized residence to suggest, yeah, it's clear the state is not in favor of this, but not to prejudge whether that's, you know, how that affects. I'm trying not to prejudge the normative issues with the term. That's why I use the term unauthorized residence. So, and for simplicity for the argument, I want to assume that the state genuinely wants to prevent these people from coming in, wants to prevent unauthorized immigration. Of course, in some cases, we all know, both in Europe and North America, unauthorized immigrants are covertly tolerated, even implicitly invited in by the state. We know that. And that obviously undermines the argument that they're there without consent. It's, you know, stop, and then bottom hands, you know. So one cannot simply infer, so that undermines the argument, you know, that they're there against the wishes of the state. The state is sending a mixed message. But on the other hand, some people say, well, if they're in, there's a demand, so clearly they're being invited in. Well, that's too strong, I think. You can't infer from a failure to deter unauthorized immigration that the state is encouraging it. Sometimes the state's effort to prevent unauthorized immigration or to expel those who are discovered may be hampered by other considerations, like commitments to certain conceptions of law or civil liberties. In the United States, there's this well-known American aversion to a national identity card. Now, whether you agree with that interpretation of civil liberties or not, you can't treat that constraint on effective enforcement, and it is a constraint on effective enforcement, as proof the state isn't serious about preventing unauthorized immigration, unless you regard similar civil liberties commitments as a spurious cover for the unless you regard it as a spurious cover for the deliberate encouragement of unauthorized immigration. I don't think that would be a reasonable inference with regard to, say, the way civil liberties hamper ordinary law enforcement, as they clearly do. You know, it's easier to enforce the law if you don't have any civil liberties out there, no question about that. And we think civil liberties are important for other reasons, so that's why we have them. But that then can't be used to say, well, you're not serious about enforcing the law, whatever the law against theft or law, you know, because they have all these protections. So in any event, whatever one thinks about the arguments for and against the degree to which a particular state is actually covertly encouraging unauthorized immigration, and I think sometimes they clearly are, in other cases perhaps not. Whatever one thinks about that, I want to take the harder assumption. Let's assume they're not, because again, that's the harder assumption for my case, which is generally going to be to defend the claims of unauthorized immigrants. So let me take the harder assumption for my own case. So, what rights should these unauthorized immigrants have? Well, at first blush, it may appear anomalous to speak of rights of unauthorized immigrants. They're violating the law by settling in the receiving state without its permission. Why should they be entitled to any legal rights? But a moment's reflection makes us aware that immigrants do, even unauthorized immigrants, do have legal rights that ought to be respected. As I noted above, there's a wide range of legal rights people possess simply by virtue of being within the jurisdiction of the state, whether they have permission to be there or not. People don't forfeit their right to be secure in their person and their possessions simply in virtue of being present without authorization. If they're accused of a crime, they have the same rights as any other criminal defendant. If they're shot or struck by a car, they have a right to receive life-saving medical treatment. And so far as I know, even the harshest critics of illegal immigration don't challenge these principles. I don't think that's really contested. So there's a rhetoric about, well, they have no, but actually that's not what people actually think. Even at least if they think that, they don't say it, because it would be embarrassing to say it publicly. By the way, it's not inconceivable. In the Middle Ages, you know, if you think we all grew up, you know, outlaws and so on. Well, in the Middle Ages, the concept of outlaw meant just that. You were outside the protection of the law. Anybody who discovered was free to do anything they wanted to you. The law would provide no protection. So you can imagine such a conception, but it's not our conception of the rule of law. Well, in addition to that, there are other legal rights that unauthorized immigrants possess that are more controversial, but still generally acknowledged. First, they should, and they do, have a legal right to the pay that they earn, even though they're working without authorization. Well, that's really just an extension of the principle they have a right to be secure in their possessions. They can be deported, but they can't be robbed. Second, they're entitled to the same legal protections regarding wages and working conditions as other workers, because these protections, whose content, of course, varies from one state to another, one country to another, they're designed to establish minimum standards for economic activities. And the fact that the workers don't have authorization to work in the first place cannot relieve employers of the duty to meet these standards. Again, this principle is generally, but not universally, generally acknowledged in practice. The recent U.S. Supreme Court decision, I'm sure many of you will know about, is obviously a move away from this standard, but that was Hoffman Plastics versus NLRB. But I think the dissent had the better of the argument in that case, and even though it's a setback, it doesn't formally reverse earlier rulings that said that unauthorized workers are entitled to their pay and other legal protections. Third, so again, it's a move in the wrong direction from my point of view, but keep in mind that it's not a complete reversal. It's a small move in the wrong direction. If they kept going that direction, that would be significant. Third, children who are present without authorization are entitled to a free public education. This is, of course, in the United States, the principle was established by Plyler v. Doe. The same practice, though, is followed in Canada and in most European states. This is particularly controversial because it requires a direct expenditure of public funds on behalf of people who are present without authorization. And it does undoubtedly create an incentive for unauthorized immigrants to bring their families in to come to join them, knowing that they'll have access to the education. But the alternative is to permit the children who do come, and they will come anyway, many of them, maybe not as many, but many, who come without authorization to grow up without an education altogether. And that is a disaster both for them and for the society in which they live. So it just is an unacceptable alternative. Well, as the list grows, you might ask whether there are any rights that authorized immigrants have to which the unauthorized immigrants are not entitled. The most obvious candidate is the right to stay. If one accepts the right of the state to control immigration, and remember, I'm just presupposing that here in the talk, then you have to accept as a corollary the right of the state to deport people who are staying on without permission. It just goes with the right to control immigration. But even that right, I would argue, even accepting that basic framework, that right does not persist indefinitely. The general principle that I enunciated at the outset, the longer the stay, the stronger the claim, that applies even in the case of people who've settled without authorization. And for the same reasons. When people settle in a country, they form connections, attachments that make them members of society over time. After a while, the conditions of admission become irrelevant. Now, again, this is recognized in practice. If you think about ordinary practices in the United States, Canada, Europe, people recognize the moral importance of the length of stay, even if it's unauthorized. And it's recognized both in the granting of general amnesties to unauthorized residents, which has happened in the United States in '86, for example, and other times, and in France and Italy and Spain, there have been amnesties. And almost always these amnesties say they're limited to people who have already been in the country for an extended period. Now, why? You think about that. Well, why do they do that? Why do they say, well, you have to have been here since 1982 or since, so-and-so. They don't start at the date. Anyone who's here now is free. You have to have been here for sure. It's a recognition of the moral relevance of the fact these people have sunk roots, they've got ties, they have a certain kind of claim. And similarly, there are often individual exemptions made on what are called compassionate and humanitarian grounds. So somebody is apprehended, they're illegally, but then you discover that, they've been there for 25 years, they got kids, they got deep roots in the community, so they can be deported, but often they won't be. And again, that's the recognition of the compassionate and humanitarian grounds are almost always linked to long residence in the country. I don't mean to suggest everybody accepts this. Of course, a lot of people don't agree with this. And the law itself almost never recognizes an individual right of unauthorized residents to stay. Very occasionally, people who have been present in the UK, for example, people who recognize people who have been there since childhood. But so not everyone, I'm not suggesting that the position that I'm outlining is actually fully reflected in law and practice. I'm just saying you can see recognition of the principle, and I'm saying it should be extended. In my own view, what you should have is a kind of anyone who manages to be in the country for a certain period of time, we could argue about how long that should be, but 5 years, 10 at the outside, without apprehension by the authorities, should then gain a right to stay. You can come forward out of the shadows and say, I've been here for X number of years, and then you should be able to stay. It doesn't mean if you catch them before that, you can deport them, but at a certain point, it just doesn't make any moral sense any longer. And of course, many people would object to amnesties, whether individual or collective, on the grounds that they reward law-breaking, they encourage more unauthorized immigration. It's true, there's something to that. But I just think that on the balance, it is outweighed by the moral claims of people living in the society. So, in my view, then, long-term settlement does carry moral weight, and eventually even grounds a moral right to stay that ought to be recognized in law. So let me say finally a few things about access to citizenship. Here in this section, what I want to get you to think about is the question, who should be a citizen? So that's something we don't normally think about. It's kind of citizenship you take for granted in the background. You might think about it in connection with naturalization or something like that. But now I want you to, why should you be a citizen? Why are you or your children entitled to citizenship? I want you to think about that fundamental question of why we think some people are entitled to citizenship at all. So not just the immigrants and their kids, which I want to look at, of course, but I want to look at that in relation to why we think we, whoever the we is, assuming that you're a citizen, you think of that as something you take for granted. Why? And you might ask why I'm paying attention to citizenship at all, given all the rights I'm arguing immigrants should have. But it remains important as you know, the measure of, first of all, the political rights are reserved for citizens, and secondly, the protections, however much one might extend the protections for non-citizens, the rights of citizens are likely to remain more secure. And thirdly, there's an important symbolic stamp of the full membership is citizenship. So I think citizenship still matters, even if one recognizes that non-citizens are entitled to a very full bundle of rights and have a very full bundle of rights. And it may seem odd to suggest, you know, even to suggest that we can decide who ought to be a citizen, because obviously handing out the allocation of citizenship, this is the construction of the political community. The foundational part of constructing a political community is determining who the citizens are. That is the construction of the community. So some people might say, well, so nobody from outside can judge. That's a political decision. It's not a moral decision. I've heard that kind of rhetoric occasionally. But I think that confuses two issues. There's a crucial difference between saying someone has a right to decide an issue and saying that whatever they decide is right. It's true that only the political community, only the states, using not small states, right, but large, only the countries can decide for themselves what their laws are going to be regarding citizenship. But that doesn't mean their laws can't be subject to critical scrutiny from the outside. That we can't say, well, that's a bad law. You're keeping people out of citizenship that should have it. And to cite some examples that I think no one would dispute today, it would not be morally permissible for a state to exclude people from citizenship on the basis of race or religion. Well, of course, a number of states did that in the past, including the United States, Germany, South Africa. Or here's another example. It used to be that states routinely made the transmission of citizenship dependent on the father's status, not the mother's. And now nobody defends that today, right? That's a kind of practice, a sexist practice from the past, and now it goes through the mother as well. All the states, almost all the states had such laws, and almost all the states have gotten rid of such laws. And it would be very difficult for a state to come forward today and say, well, we've decided to go back to that. We'd eliminate, reduce this. And the justification was clear. You know, in case of mixed marriages, it reduced the problem of dual citizenship. Well, I invite anybody to make that argument publicly today. You know, they won't get very far. Okay. So what does justice require, and what does it permit with regard to access to citizenship for immigrants and their descendants? So let's look first at as I said, let's look at access to citizenship by the children of citizens, because citizenship is a status that's normally acquired at birth, most people. So you might ask, how can anyone deserve anything at birth? You haven't done anything to deserve it, and that's certainly true. Nothing personal that you've done to merit citizenship. But you can deserve it in the sense that denying citizenship to someone situated in a particular way at birth would be wrong. So let's take what we call the normal case, which everyone assumes, but I want you to think about this normal case. A child is born within the territory of a state in which her parents are already citizens, right? Everybody in that case, every state grants citizenship to, if your parents are citizens and you're living in the state in which they are citizens, you're born, you're a citizen. Bingo. Everybody does that. Why? Think about it. Why? It's not just an, you know, because, well, we have a world divided into states and it has to be that way, but it's not just an administrative, you can imagine people might not want to do it. Yeah, well, we're going to, this subgroup, we're going to start keeping outside of citizenship. Or, you know, maybe we're worried they'll leave. It's not seen as an option. Well, citizenship is, and the answer, it would be morally wrong to deny citizenship to such children, not just a bad administrative practice. Because citizenship is the status that establishes one's position as a full member of a political community. Though, of course, it's an infant. It can't actually do anything, right? But the children of citizens are born in a state in which their parents are citizens. They're morally entitled to that status because of the social ties between them and the wider society that are created by and foreseeable from the circumstances of their birth. It's only reasonable to expect that these children will grow up in the society in which they've been born. They'll receive their social formation there. They will acquire a fundamental interest in being able to participate as full members of the political community. And that's why they deserve citizenship. Now, of course, it's only reasonable, but that doesn't mean it'll happen. These expectations may not be fulfilled. The child's parents may take her to another country at an early age. She may choose to leave herself as an adult. But these possibilities are not enough to make the transmission of citizenship contingent, dependent on how things go in the child's life. We could imagine a different system of citizenship where you don't get it till you become an adult, but of course you need citizenship at various younger ages for various legal purposes, so you can't quite imagine that. Or, you can imagine citizenship leaving when you left, but then what about coming back and so on. So the way it works now, we could imagine different systems of citizenship, but right now citizenship that you acquire at birth, you have it for life, unless you do something to give it up. So that's what happens if you're born as a child in a country, child of citizen parents. Unless you give it up, you've got it forever. Well, now think about departures from that norm, the children of citizens who live outside their country of citizenship. So far as I've been able to determine, if the parents once lived in the country for some period of time, every country in Europe and North America grants their children citizenship at birth. Though in some cases that might be made contingent. If they've got another citizenship, it made contingent on them spending some time in the parent's country before a certain age, or else they lose it. But at least they have a claim to citizenship. It's like my kids, for example. So they're born in Canada. They get citizenship by birth in Canada, but they also get American citizenship by birth because we're Americans. Both their parents are Americans. Even only one would be enough to transmit it. But this is limited. See, my kids won't be able to pass on American citizenship to their kids unless they come back to the United States and live here before they have the kids, or live here for a certain period of time before they have kids. So otherwise it ends. And that follows the normal pattern. I'm not aware of any country in Europe or North America that provides citizenship on the basis of descent, no matter how remote. If you can just find some citizen ancestor, you have access to citizenship. Nobody has that kind of unqualified transmission. Well, what do we make? That's just the description of how it works. What do you make of this pattern from a moral perspective? I think it's generally defensible. They reflect the same normative logic that informs the automatic granting of citizenship to the children of resident citizens. Namely, they have a moral claim to the citizenship that depends on their social ties and on the likelihood they'll actually live in the community. So for the first generation born abroad, the parents' connections to the community of origin are sufficiently strong to create a powerful interest for the children to have a right, say a right of return, a right to go there where they've never been, and settle there, whether with their parents or as an independent life choice. So, of course, one point of them having citizenship as children is maybe the parents decide to come back. If they didn't have citizenship, you got a whole problem of immigration control. So, they have to have that. Plus, but maybe as adults. I mean, my kids, for example, all of our relatives in the United States. So maybe my kids decide to come they have a lot of attachments here. So maybe they decide to come. And so it'd be wrong to deny such children some effective access to citizenship, some kind of claims, at least through their minority. But the ties are much weaker in the succeeding generation and of vanishing significance after that. If my kids don't come back to the United States, well then the relations are distant and so on. They've formed their own lives. Their children will have very tenuous connections. They don't really have any claim, and their children's children, no claims, assuming that they all stay settled in Canada. So it'd be wrong to regard citizenship in liberal democracy as a kind of feudal title or a property right you could pass on from one generation to the next, regardless of where people actually live their lives. As the proximity to an ancestor who lived in the country decreases, so does the plausibility of any justification for automatically granting citizenship. Well, now, what does this suggest about access to citizenship? Now, let's get to the immigrants. What does this suggest about access to citizenship for them? Well, what matters normatively are the strength of one's social ties, the likelihood one will spend one's life in the community. What justice requires is that the descendants of settled immigrants be granted citizenship automatically, as the children of citizens are. You should expect that they'll grow up in the new country, receive their social formation there. We have every reason to believe that such children will live their lives in the same kinds of reasons, really. They'll live their lives in the society and they have a right to be treated as full members of the political community. The state has considerable power to shape their social formation through systems of compulsory education and by other means. These children cannot rightly be subjected to any tests of acculturation or adaptation as a condition for acquiring citizenship, just as the children of citizens are not subject to such tests. Note the crucial variable here is not so much place of birth, as it's often treated, as the place of social formation. So I would say the claims to automatic citizenship apply just as fully to children who arrive with their parents at an early age, at 2 or 3 or 4, as to those who are born here. And I'd go further and insist, though I can't spell this out in detail, that it would not be sufficient merely to give them a right to citizenship, leaving it optional whether they took up that right or not. That's not how we do it with the children of citizens. It would be wrong to make it just optional for them. And for the same reasons, it's wrong to make it optional for the descendants of immigrants who grow up in a country. They should get it automatically at birth if the child is born in the country and the parents are permanent residents, or automatically at some later stage, say after a certain number of years of schooling, if the child comes at a young age. Of course, I don't mean to deny the right of expatriation. If you choose to, leave the country and give up your citizenship, you can do that. But everybody can do that, not just the children of immigrants. And usually you can't give up a citizenship unless you leave the country. That you can't give up your citizenship while you're inside the country and still stay there. And you have to sever the key social ties that undergird citizenship. And then if you move abroad and settle and you want to renounce your citizenship, you can do so. And of course, that would be possible for these children of immigrants as well. Well, if you look at practice, we can see that reforms in citizenship and naturalization laws in a number of European countries in the past few decades have produced dramatic changes in access to citizenship for the descendants of immigrants that fit with the normative logic that I've outlined here, even if they don't always go quite as far as I think they should. And these reforms have been introduced in the face of deeply entrenched conceptions of citizenship and of political community that many people said would make these changes impossible. In general terms, and with occasional exceptions, the pattern is this. There's widespread acceptance of the view that excluding the descendants of immigrants from citizenship, generation after generation, is incompatible with any plausible account of liberal democratic principles. And with all the rise of the right and Le Pen and all that, this basic view has not really changed. That even these, there are exceptions to all these generalizations, but nobody really thinks you can have a democracy in which generation after generation after generation is excluded from citizenship. That contradiction is just too blatant. So, countries with traditions of jus sanguinis, which is to say the transition of citizenship on the basis of descent from citizen parents, which most of the European countries had, they've supplemented these rules with provisions for the acquisition of citizenship on the basis of jus soli, transmission of citizenship on the basis of birth in the country, for children who are born to parents who are permanent residents. Almost every European country now has a law providing for automatic acquisition of citizenship by the third generation. That's the children of the immigrants, right? And for automatic or at least optional acquisition of citizenship by the second generation, the children of the immigrants who were born in the country. Well, in North America and Canada, Canada and the United States have had the common law tradition of jus soli. Anyone who's born in the country gets citizenship. And so North Americans have tended to be kind of smug on this point. They talk to the Europeans, well, we have no problem in the second generation because we have jus soli, we're so more progressive. Tending to overlook the fact that the reason we have a jus soli rule is because the British kings wanted to consolidate the monarchy. It has nothing to do with integrating immigrants. It has to do with the historical accident. This was introduced in the 16th century as a way of consolidating the monarchy and asserting its authority. And it just has passed on through the common law tradition. And there's a second reason not to be too smug about this, which is the complacency about the integrative effects of the jus soli rule has led North Americans to ignore the claims of those in the second generation who were born abroad, so don't acquire citizenship at birth, but come at a very early age. So it leads to these really, I regard as serious moral anomalies where you have these kids who have been here since the age of 2 or 3 or 4 who get deported in their 20s and 30s. And, any reasonable conception, whatever you might argue about people who come as adults, any reasonable understanding would recognize that's unfair. So, and that happens because we don't worry about that group because we know the second generation is taken care of. So access to citizenship for the members of the second generation, more broadly construed, the children of the immigrants, is sometimes better protected in European legislation than it is in North America. Now, I will say that I think a strong jus soli rule, such as we have in Canada and the United States, is stronger than justice actually requires. Some people, the UK, Australia, Ireland, have reformed their jus soli laws to make citizenship apply only to those who are the children of citizens or permanent residents if you're born in the country. Whereas what happens in Canada and the United States, you can be a tourist, you can be a visitor. If you happen to give birth, whether you're authorized or not, if your child is born, of course, you become a citizen. And so some people say, and I don't think it was wrong of these other countries to change these laws. But I do think it would be, but I'd had two true provisos to that. First, if people are raised in a society, they should automatically acquire citizenship regardless of the legal status of their parents for the reasons that I've laid out. And British law, for example, recognizes this. If you're born in Britain, without your parents aren't in this permanent residence. But if you live there for the first 10 years of your life, you become a citizen automatically. That's a partial recognition of this kind of claim. And the second thing is, I'd say, it's a kind of contextual argument. It would be wrong for the United States to modify its jus soli provisions. And that's because these are tied in the United States. This is a kind of historical and symbolic argument, the contextually specific argument about the United States. Jus soli in the United States is also tied to the 14th Amendment, though it emerged through the common law. Then the 14th Amendment that abolished slavery introduced the jus soli rule. Anyone born in the United States is a citizen of the country.
Excuse me, that was the 13th. And the 14th Amendment is not properly taught in this university.
Oh, sorry, yes. But the 14th Amendment did establish the jus soli rule. 13th Amendment, well, the 14th Amendment is the one that establishes the jus soli rule.
Establish what?
The jus soli rule, the provision that anyone born in the United States is a citizen, is the 14th Amendment, is it not?
Subject to its jurisdiction, meaning the District of Columbia and its territory, meaning
Yes.
Samoa, Guam, Virgin Islands.
So the,
California is not a state as defined in the Internal Revenue Code.
right. As my commentator suggests, there is there is a scholarly dispute about and some people have written a book. I've actually got a long critique of this book by Roger Smith and Peter Schuck, which argues that the constitutional provisions of the 14th Amendment regarding what it means to be subject to the jurisdiction should be interpreted in a way that would exclude the children of unauthorized immigrants. I think this would be a terrible mistake, because because if you look at the series of laws that you'd have to, the series of cases you'd have to endorse in order to defend that interpretation, it starts with you know, what's the famous the Civil War, the thing that Dred Scott. It starts with Dred Scott. It goes through a series of other cases that excluded the Native Americans, that or would reverse the cases that protected the rights of Chinese immigrants and so on. So it would be a terrible symbolic and constitutional history if you tried to do it by interpretation. And for the same reason, symbolically, it would be a terrible mistake to tamper with the 14th Amendment because of the importance, in my view, of that amendment in American history and culture. In Canada, it doesn't have the same kind of constitutional status or constitutional history, but I still think it would be a bad practice to change it because it's good for the to communicate Canada's basic stance for immigrants. Well, I have some comments on first-generation immigrants, but I think I've tried your patience long enough. I think I'll stop there. Thanks very much. I hope I've given you a few things to think about.